And then, yeah, I'll go ahead and let everybody in and we'll get started. Great.
Okay.
All right. Hello, everyone. Bit of an echo there. All right.
Need help?
I think we're good. We'll go ahead and get started. Thanks, everybody, for joining. We are excited to have you all here today. And we're going to talk about the legal aspects of caregiving. I'd first like to start by introducing our speakers. So today we'll start off the session by hearing from Patrick Cawley, owner and attorney at Keystone Law. He will discuss the legal foundations of caregiving. From there, we will go to Nancy Myers, founder and CEO of Advocord, who will discuss the fiduciary aspects of caregiving. And last but not least, we will talk to Nat Robinson, founder and CEO at Trustworthy, who would talk about how best to organize precious documentation so you're always ready as a caregiver at a moment's notice for anything that you might need from a preparedness perspective. With that, Patrick, I'm going to kick it over to you to get started. Oh, before we go there, if you have any questions, we'll have time at the very end of the session to go through questions. You can see in the bottom corner, there's a little kind of hamburger looking little dot square section. If you click on that, you can enter your questions in the chat, and then we'll go through those at the end of the presentation. We'll go through people's questions then. So you can please make sure you're on mute in the meantime. And from there, we'll kick it over to Patrick.
Okay, thank you, Kate. I'm Patrick Cawley with Keystone Elder Law. I'm in Pennsylvania, and some of these rules will be a little different in whatever state you live in, but I'm going to hit the high points, understanding I could speak for hours about this, maybe the most important things you need to know. And really, when we talk about the legal aspects of caregiving, we're talking about health and medical decisions, and we are talking about financial and property decisions. So first things first. What are the most important things you need to do right off the bat to set the stage for everything else? You want to know who your team is. You want to have conversations, and you want to do some record keeping and document everything. So the team, I mean, if you are a caregiver, you probably already know that the tasks of caregiving are difficult enough. So maybe don't do that by yourself. You might burn out. You might injure yourself. So maybe you're already bringing in other people as caregivers onto your team, but you might want some professionals on your side as well, especially once you see how detailed some of these legal and financial issues are. Conversations, two types of conversations, medical and quality of life decisions. And then on the other hand, financial conversations that are going to happen. So let's talk about that. On medical conversations, you want to speak to the person receiving care, and your North Star is what that person believes is quality of life for them. And so even if it's just what brings them joy, because ultimately, if you have to make a medical decision, I talk to doctors all the time, as recently as yesterday, and they say, people hear your care recipient might make it off the surgery table, but that's all they hear, and they don't hear what happens after that. Will the person ever use the bathroom by themselves again? Will they need assistance throughout the day? Well, is that consistent with what quality of life means for that person? So you want to have conversations about what brings the person joy. What kind of medical decisions would they make if health started to decline? And don't accept as an answer, just take me out and shoot me. I hear that all the time. I can think of a lot of care strategies, but committing a homicide is not one of them. So you want to get very clear on quality of life. If the person cannot have that conversation with you, maybe because of cognitive decline, dementia, a stroke, something of that nature, speak to everybody else in the family. get their input. And what you're trying to figure out is, what would this person define as quality of life? So that's the North Star. Solicit that input. Even if you personally disagree with what the person would say, you need to be ready to channel that person's wishes for quality of life. A suggested resource would be theconversationproject.org, theconversationproject.org. That will give you some ideas for that conversation. On the property and money side of things, you want to start gathering everything that this person who you are caring for owns. So you want to know, what bank accounts and credit union accounts do they have? What investment accounts, brokerage accounts do they have? You want to know what real estate they own. You need to assemble the list of everything. And if maybe you already have a list from that person, you are fortunate if you do, but you want to start record keeping. Just get your hands around everything they have. And it's not just what they own, but regular bills, subscriptions, memberships, passwords, which can be a real pain in the neck, but it's part of managing somebody's property. So you want to know what they own. You want to know where the Social Security income is going, what account is that going into. Once you've established these first things, you're ready to get into the action of the legal aspects of caregiving. So let's talk about medical decision making. Now that you understand what your North Star is with quality of life, well, every single person, including you attending this webinar, has a legally protected right to hear a doctor say, here's your problem, here is the proposed course of treatment, and here are both the pros and the cons. So they'll tell you the benefits, but they'll tell you the downside, the risks or the side effects or the procedure you'll need one day. And you have a right, the person you're caring for has a right to take in that information, weigh pros and cons, and say, yes, let's do the treatment. Or, no, I don't like the sound of what that's going to do to my quality of life. So the document, legal document that allows you to make that decision for another person is the healthcare power of attorney. And the second half of it is the living will. This goes by different names. It might be called in your state an advance directive, a healthcare proxy. It's the same thing. Someone has delegated to you the right to say yes or no to a treatment. And that living will is an expression of wishes based on quality of life for what treatment to extend the days of life are appropriate, or maybe that's not the goal at all if health starts declining seriously and the end is coming near. Maybe it's no longer the goal to add days to life, but you want to know, look at, does this person even have a healthcare power of attorney or advance directive? Are you the person empowered legally to speak for them and make such an important decision? If there's a living will, what does it say? Based on your conversations, you kind of know scenarios where you are going to say yes to treatment. You're maybe going to get a second opinion, but you're ultimately thinking of quality of life when you say, yes, let's do the treatment, or let's not do the treatment. So get to know that document if there is one. It should have a HIPAA waiver so that you don't have to worry about privacy laws. You can hear the relevant health history and make informed decisions for another person. If your care recipient does not have one, most states, I think all states actually, have a default law. In Pennsylvania, my state, it's called the Healthcare Representative Law, and it just says family members. So a spouse, and if the spouse is not around to make that decision, all the children. So that's not as ideal because it's not one person who's empowered, it's everybody. But know that if you can't get a healthcare power of attorney for your care recipient, that might be the default position where you are just by law making medical decisions. So conversations and then the legal authority to make medical decisions. Let's talk about the financial power of attorney. In my opinion, this is the most important part of a person's estate planning. If your care recipient does not have one of these, make it a very high priority to get one done. And if the person is already completely cognitively impaired, it won't be possible. And the alternative might be guardianship or conservatorship, roughly the same thing. It's just called different things in different states. But that would be a court process, because either way, whether it's a power of attorney or guardianship or conservatorship, you need to stand in the shoes of another person. You need to access the accounts that you created in that list, all the money they have. You need to pay their bills. You are acting as that person. It is the highest form of trust that a person can give to somebody. So, for example, in my own power of attorney, I name my wife to be the decision maker. If I'm in a terrible accident or if I have a health decline, she can get into my retirement account and pull money out. She can change beneficiary designations. To sell our house, both our names are on the deed. She can sign her name, but somebody has to sign for me to sell that house. She can sign her name, comma, POA, and be me selling that house. So it's a big deal. So if there is a power of attorney, you want to get to know it. Number one, there are format requirements in every single state. So probably it had to be signed in front of witnesses and a notary. Maybe you as the caregiver had to sign something accepting a responsibility. But okay, so is that done? Next, you're going to read the power of attorney. It's dense legal language, but it's what you're allowed to do. So number one, are you even the person who is empowered legally to get into a bank account or talk to an insurance company? If there's somebody listed before you, maybe you're caring for mom and dad was listed first, but dad died a couple of years ago. Okay, you need to document why dad is not the one talking to the bank, maybe with a death certificate. And then you sign whatever form to accept the responsibility and you're off and running. So are you even the person who is authorized to act on behalf of the person receiving care? Number two, you're going to want to know, what does it allow you to do? So hopefully it allows you to speak to financial institutions and insurance companies, but go through and make your best effort at understanding the powers that are in there. Does it allow you to pay for other team members as caregivers? Does it allow you to, using the care recipient's money, does it allow you to pay yourself? Sometimes that's appropriate. And so that has to be authorized before you start giving yourself money. Bottom line here, and you will hear more on this from another speaker, but you will have a fiduciary duty, meaning in the shortest possible way, you are looking out for their best interests. You're paying their bills, you're getting their tax return filed, you're doing all the things they would have done for themselves, and you're not lining your own pockets. That's a general guiding principle. Look, caregiving is hard enough. Maybe you feel like it's a thankless job. Maybe you're getting criticism from other family members and friends. The last thing you want is for Adult Protective Services or a family member accusing you in court of lining your own pockets with money. So back to record keeping, you want to, whether the law requires you to be an open book or not, my strongest recommendation to you is to document everything you do. Here's the money we have. Here's the bills I'm paying. Be an open book about this, even the time you're spending on all of this, and be an open book to other people who might have an opinion, because people fear the unknown and then they just jump to conclusions about what you're doing and it might not be accurate. You want to show your work so that you avoid any sort of unnecessary accusations. That's one of the best things you can do, and the other speakers will give you a lot of information about how to document your work. When you use the power of attorney, expect pushback. Financial institutions are experiencing unprecedented levels of fraud. So you're very rarely going to walk into a bank and get into your care recipient's accounts. You're going to show them the power of attorney, show your ID, maybe sign a form that says the person is still alive, this is still a valid power of attorney, and then they will take some period of time to run it up the chain of command, make sure it's valid, and then they will let you in. Small community banks, you might do it in the same day. You might start transacting business, but more often there will be some period of time until they approve it and allow you to do work in that account. Know that some financial institutions just thumb their nose at state law and they say, we have our own form. This is where attorneys can be helpful. And the suggested resource here is if you Google NAELA directory, that's N-A-E-L-A, NAELA, it's the National Academy of Elder Law Attorneys, NAELA directory, one of the first Google results, you click on it and you can put your zip code in and within 25 miles see all of the elder law attorneys. They know how all of this works. You can find somebody to join your team and help you through any pushback from a financial institution. One other form of pushback, You would think that a power of attorney valid under your state's law would allow you to get the tax return filed, to deal with the Social Security Administration, deal with the VA. But federal agencies do not automatically accept a power of attorney. But there's still a path forward, and the power of attorney is still relevant. It's a sign that you were a trusted person. My suggested resource here, because just for time purposes, is to check out a website called Careful List. And Careful List is careful list, all as one word. And it's all kinds of resources for caregiving. But if you click on the blog section, you'll see 2 articles that I wrote that go into great detail about the process if you want to deal with Social Security. Because let's say dad is cognitively impaired, he's going into his account and just pulling all the money out, more than is there, and you need to protect him. So you're having the Social Security income directed to a different account. That's called being the representative payee. There's a process. You show your power of attorney, but you have to make an appointment with Social Security and become the representative payee. You also can't just file a person's tax returns. You have to go through a process of getting approved by the IRS, and you'll show your power of attorney. But I write about this on Carefulist in much greater detail. So step by step, what you need to do there. Revocable trusts. A lot of you live in states where those are very, very common. And for any property that was transferred into a trust, that will kind of act like your power of attorney. So if you are the trustee, it's the same thing as being named as in a power of attorney for purposes of that property. There's an element of incapacity planning there, where you can carry on business of property that's in a trust. But I do suggest checking out elder law attorneys who might guide you through those legal aspects. I know that we have other speakers and we left some time for questions. I said I could speak for hours, but if I had more time, what I would go into after the healthcare power of attorney and the financial power of attorney, with all of your understanding of quality of life and your understanding of the money and the property and your record keeping. That's really the most important part of the legal aspects of caregiving. But what other questions might you have? Levels of care. So you might be providing care in a person's residence or in your own residence. Maybe if they're in another residence, you did the Postal Service mail forwarding, and now you're changing addresses. So bills and financial statements come to you. You add that to your list of assets. But what if care leaves the home setting? What if it goes up a level to assisted living or memory care? What if it goes to the highest level of care, the skilled nursing facility? How will you pay for it? Kate, cut me off whenever you want to move on to the next speaker, but I could go on and on about this. Let's just say there are 3 general ways you'll pay for that care. You're going to write checks as power of attorney. You're just writing checks, private pay. And that might be, with enough money, a sustainable strategy. Or you might have long-term care insurance. And if you find that when you are compiling all of the assets, the accounts, the bills, the passwords, that is a legal contract. And the insurance company will not pay 1 dime for care until you meet the elements that are listed in that legal contract. For you have to have this present, and then the insurance company pays. Shortest possible answer on that long-term care insurance policy is do not just call or write a letter and make a claim. Because if it says you have to show activities of daily living that are impaired, you have to have that evidence ready. Like you're going to court and you're building your case. The first step would be making a doctor's appointment. Because and you tell the doctor, we need paid caregiving. I need the insurance company to pay for it. And I need to show that the person cannot get out of bed on their own. They can't dress themselves. They can't get food from a plate to their mouth. And the doctor knows what this means. That all goes into the notes. And that those medical notes are the first thing the insurance company grabs to see if you're even eligible for the insurance company's money. So when people get very frustrated that claims are denied, it's usually because they didn't tell the story of eligibility. And the final big way that people pay for, especially skilled nursing care, nursing home care, is Medicaid. And that's about, and every state does this differently, but how much income does your care recipient have? What assets do they have? Because they're not allowed to have much, but there is a process that the person from NALA can help you shift assets around, keep the money in the family, and get your care recipient eligible for Medicaid. But it's all against the backdrop of what you might have heard of, the 5-year look back, where they look at what gifting has been done in the last 5 years. So again, not only with your fiduciary duty, but for Medicaid purposes, you want to be very careful about transferring money or real estate out of the name of your care recipient, because that could come back to bite you with Medicaid eligibility. That 5-year look back, they want to find anything that has been transferred out of the person's name. Throughout all of this, and I do want to yield to the other speakers today, there's some very helpful people to speak with you. But if you feel like this is a thankless job, if you're thinking your life is on hold, I am a family caregiver. I know the psychology of this. It can be, there are days that are great and it brings you joy, and there are days when you just want out. I recommend you Google Barry Jacobs, and you might add caregiving or AARP. Barry Jacobs is a great psychologist who really specializes in the psychology of being a caregiver. Don't burn yourself out. Get some insights from Barry Jacobs. He writes many articles. He has a few books out there, and get help. But hopefully this starts the thought process on, what am I supposed to be doing? What are the legal tools? What kind of record keeping should I be doing? And with that, Kate, I'm not even sure. I haven't been looking at the time, but I want to leave time for questions, so we can go on to the next speaker.
Thank you so much, Patrick. That was super helpful. And again, for those joining late, if you have any questions, please enter them in the comment section. We'll cover questions at the end. And from there, we'll hand it over now to Nancy, who's going to talk more about the fiduciary side of caregiving.
Hi, everyone. As Kate said, I'm Nancy Myers. I'm the founder of Advicord, which is a software company. We basically created accounting software for people who are fiduciary caregivers. And I'm going to talk exactly about what a fiduciary caregiver is. I'm also a practicing attorney in Pennsylvania, although I'm not here to give any legal advice. So there's your disclaimer. As Patrick pointed out, I mean, caregiving is an all-encompassing endeavor, and there are so many facets to it. But one aspect that I really think gets a little attention, and why I'm very thankful for Trustworthy for putting this seminar together, is the legal aspects of it. Is what does it mean to be a fiduciary caregiver? So, Patrick mentioned you've got agents under powers of attorney, you've got representative payees for Social Security, you've got guardians, you've got conservators, depending on which state you're in. And most people kind of think about these relationships very casually, like, oh, I'm just helping mom pay bills. And, they kind of ease into it, and they don't really give a whole lot of thought to the gravity and the potential pitfalls of what taking on that responsibility can really mean. And add to that, most people in this role have never done it before. There's no family training for this. You're just sort of thrown into it. So, Kate, I think we can advance the slide here. Great. So when I mention, fiduciary caregivers, you think, well, what does that mean? What is a fiduciary duty? Well, really you're talking about somebody having a legal obligation to care for a person. Certainly we have familial obligations or obligations based on friendship or relationships, but this is one where there's actually a legal obligation in place. And that is a legal obligation to act in the best interest of another person. And they're typically created by powers of attorney, guardianship positions. So that's what we're talking about when we're talking about these fiduciary duties. So then the question is, well, what are the components of fiduciary duties? We've thrown that term around a bit. And there are many components to it. So let's start with loyalty. This at its basic core is meaning at 100% of the time, you must solely act in the best interest of the other person. So common breaches occur where the caregiver kind of, blurs that line a little bit and starts making decisions maybe not 100% in the person they're caring for. One example I'll give you is, let's say, mom has advanced dementia. She owns the house she's still living in. Daughter is an heir under the will. She wants the house now. She doesn't want to wait until mom passes away. And all of a sudden she uses the POA to transfer mom's house to her for $1. And now she owns the house. Clearly that is self-dealing, and that is a problematic area. I think another area comes in with respect to medical decisions. So let's say, the person you're caring for needs a high level of medical care. That's what's recommended, but it's very expensive. And, you start saying, well, I don't know that I want to do that because that's going to eat up a lot of the money and then I'm not going to get an inheritance. And, that's where, although a child is typically the agent that's chosen for a parent, there's also that natural conflict of interest kind of baked in there that you have to be very careful about. And you have to really say, wait, I'm wearing two hats. I am the child, I am a potential beneficiary, but the more important role I'm playing right now is the fiduciary caregiver. And I need to do what is absolutely in the parent's best interest, because otherwise you could be looking at a breach of that duty. Another component to fiduciary duty is care. You must make informed and prudent decisions. So even if you have a high personal tolerance for risk in making investments, you really cannot take that risk with other people's assets. You can't just research on the internet about the latest startup and invest all of dad's money in that. You really should be working with a financial advisor to diversify the portfolio, to make sure that you're making decisions that don't disqualify a person from benefits down the road. So, again, you really want to say, this isn't my decision for me. This is the decisions for somebody else. So I really need to use the highest level of care possible. Another scenario that I'm seeing more and more is, what steps do you need to take to protect the person from scams? And that's sort of an emerging area, because with a power of attorney, it's important to remember a power of attorney doesn't negate a person's ability to act on their own behalf, even if they may not have the cognitive ability to make decisions prudently. They still legally have the ability. So, what are you doing to sort of minimize the risk? So I would give an example. If the person you're caring for has a series of in-home care providers coming in and out of the house, I wouldn't keep a lot of cash in the house. Just simple things like that, simple steps to take that are just prudent. Another area is confidentiality. This is another component of fiduciary duty. You must protect private information about the person. Sometimes people get tripped up with social media here. You have to remember, especially if the person can't consent to having their life broadcast on social media, then maybe it's time to scale that back. Another component is disclosure. So, so I said, conflicts are sometimes inevitable, especially when it's a family member as the agent under a power of attorney. But they must be disclosed, and sometimes those conflicts of interest aren't bad. So let's say you sign a contract with a realtor, you have to sell mom's house and the realtor just happens to be your fiance. Okay, well, on its surface, it seems like that might be a conflict of interest. It's certainly something you should disclose, but it may be something that's actually good. If your fiance has agreed to cut the commission in half from any other realtor and it's going to save mom money. Okay, well, that might be a reason to proceed with that contract, but it still should be disclosed that there is a relationship there. Next component is good faith. This is something you just have to act honestly and with honorable intentions. I always tell people, look at what does it look like? Is there an appearance of impropriety? Or, some people use example, does it pass the smell test? Does it just seem a little off? Just being above board at all times is really a key component to these fiduciary caregiving duties. The next one, absolutely accounting. As Patrick said, you cannot have too many records. You absolutely have to keep records. And this is where even the most well-intentioned people get in trouble. I've had clients that literally come with shoe boxes filled with records that are completely disorganized. They're not sure, what years they're from. There's no organization to it. Every single transaction, every cent you are spending for somebody else has to have a record. Receipts have to be kept. And there are different methodologies to do that, but you have to remember that fiduciary caregivers are under a constant obligation to be able to account for everything they do. If you are a power of attorney, most states have statutes that allow a court to order you to provide an accounting. of what you've done. And they'll tell you the time period, and they'll tell you who you have to disclose it to. That can be daunting if you don't have good records. If you have good organized records, it's not that bad. People who are court-appointed guardians or conservators have an absolute mandate. Most states, it is an annual report that you have to provide to the court that gets examined. Most states have some sort of auditors and review processes that go on. And if there's something out of whack, you're going to be called in front of a judge to answer. So you really have to take a bit of a defensive posture with respect to keeping records. You have to think, wait a second, someday I need to tell somebody exactly what I did, so I'm going to have the record. The other reason to do this is if you're looking at entrance into a nursing home, they're going to want full financial disclosure, as Patrick, certainly mentioned in his presentation. So not having organized records is going to be a really tough hurdle to cross, and may actually result in a delay of entry and a delay in services being provided to the person you're caring for. So there certainly could be, some negative repercussions to the person you're caring for as well as you. The bottom line is you simply cannot have too many records. The final component I would mention is obedience. And what I mean by that is your power is limited to the document granting you the authority. So not all powers of attorney are alike. They grant different powers and different scenarios in which you can exercise those powers. The bottom line is, before you make any decision, you must always return to the document, be it a power of attorney or a court order, to determine whether or not you actually have the authority to do that. Like I said, they are not all the same. And by acting beyond the scope of your authority, that is considered a breach of your fiduciary duty. A lot of problems come up with selling real estate if you're a guardian or conservator. Almost every state, and I think actually everyone, does require a court order before you sell real estate of the person you are caring for. So listing a property, and I've seen it in my law practice too, where we get to the settlement table and, somebody says, well, wait a second, where's the court order permitting the guardian to sign over the deed to this house? So, again, you're constrained by the terms of the document that grants you the authority. And in addition to that, there are even state statutes and regulations that can actually, restrain what you can do on behalf of the other person without court order. There are certain mental health treatments, for example, that require a court order. So the bottom line here is, it is crucial to get good legal counsel and advice when you're doing this, at least at the beginning, to help guide you and give you a roadmap of what decisions you may need to make on behalf of the other person. All right, next slide. So I said you have to take a defensive posture. So, well, why is that? Well, because there are some pretty bad consequences to breaching fiduciary duty. I used to do some litigation in this realm, and I will tell you, those family fights are not pretty. They usually occur because somebody feels that they're out of the loop, that there wasn't transparency, that there wasn't good record keeping. So failing to be able to document something can really result in family squabbles, which can end up in court, which means you have to spend a lot of money on an attorney, and it's a lot of stress. And frankly, it fractures families, usually permanently. I'm sure Patrick would probably agree with that, but they're tough to walk back from once they happened. Other repercussions for breaches of fiduciary duty: you can be removed by the court from your role as an agent under a power of attorney. You can be removed as a guardian. You can incur personal financial liability if one of your decisions resulted in financial losses to the person. If you breach that duty of care and all of a sudden the person lost a lot of money, you are potentially personally liable for that. And more states are requiring that fiduciary caregivers post bond which is an insurance policy, especially in the guardianship or conservatorship realm, an insurance policy to guard against losses. And finally, the most extreme consequence to a breach can be criminal penalties. So, Pennsylvania, for example, pretty recently enacted a theft statute that it imposes harsh penalties for the theft of someone with a close relationship to an incapacitated adult. It's called the exploitation of a dependent adult. The interesting thing about this statute is there's a provision in there that says anyone acting under a power of attorney is presumed to know and understand the entire power of attorney statute. So in other words, what they're saying is that if you are a fiduciary caregiver, you're actually held to a higher standard for these impositions of criminal penalties. So certainly this is I don't want to scare, I know that sounds scary. It's a crucial role that needs to be filled, but the bottom line is you cannot have too much education on this. And you really need to put in place a team of advisors that can help you navigate this. So at this point, I will turn it over, I guess, to Nat. I think we're going to do questions at the end. There's a coupon there for anybody that wants to try Advocord. It's in the Trustworthy Marketplace too, if you want to get that. So that's it. I guess we'll talk at questions.
Yeah. Thanks, Nancy. Hi, folks. I'm Nat Robinson, founder and CEO of Trustworthy. Thanks to Nancy and Patrick for their presentations. Really fascinating stuff. I just want to recap what I heard from them. An amazing breadth and depth of the kinds of documents that you and record keeping that you want to keep track of. And Patrick described it nicely, his situation for his family and his wife and what they're set up to do. And we talked a lot about caregiving for elders. And I think that's a big part of the moment that we're in today is a lot of Gen X folks, sandwich generation folks, thinking about their own households and thinking about their elder parents, this generational transfer that's happening as the baby boomer generation retires. And I think this number that goes up every time I see it, 100 trillion in assets passing from one generation to the next. That's a big moment. And there's a few others that I want to just describe that we're all dealing with. Another one is digital transformation. So we've seen this, last 60, 70 years, obviously the information age, we're all part of it. The amount and number of bits of information that we all now need to keep track of. We hear, from tens of thousands of families that we support, it's all over the place. I have little silos of information all over the place. I used to be able to keep a filing cabinet, and now it doesn't always arrive in the mail or as a piece of paper. It arrives digitally. Where do I keep track of this stuff? How do I deal with that? So that's a moment. We talked about generational transfer, wealth transfer, climate change. You see this in the news almost. Floods, fires. We had a lot of clients in LA last year who lost their entire homes, all their records. Fortunately, they had everything backed up and Trustworthy. They're okay, but not everyone was in that situation. Tornadoes, hurricanes, on and on, right? There seems to be an increase in the violence of these kinds of storms and the frequency. That's something you need to think about. So a lot of different moments happening across society. I'm not even going to touch geopolitical unrest, but that's a thing that's happening as well that we're all aware of. How do you deal with that in your life? How do you deal with all these bits of information all over the place? When we started 5-6 years ago now, we were really surprised that there wasn't something. We're 70 years into the information age. Families don't have a system of record. What are they doing? Well, it turns out they were all DIYing it. They were all cobbling together their own systems to try to deal with this problem, this growing problem. It's not a problem that's going to go away. It's getting more complex, and the amount and bits of information we'll need to manage is only increasing. So they were pulling together, I use the Photos app on my phone. I put important documents there. I use, Google Docs. I use email. I use whatever tools I have at hand that I understand. And still I have silos all over the place. And we were inspired by some of the systems that we've seen built. There was clearly a need. People had, either shoebox or some beautifully elaborate system that they built in a spreadsheet. And that was inspiring to us. We said, look, surely not every family should have to invent this from the ground up. Could we help with that? Could we help them get further, faster, and maintain this across their lives, across the life of the system that they built? How do we help them build it quickly, maintain it over time, not stuck with the blank page, get guidance as they go through it? What would that look like? So we built the family operating system, is what we call it today, by Trustworthy. And we help you organize your most important information. Some of those really important documents that Patrick and Nancy described, and lots more. So we talk about family identity, passports, driver's licenses, membership cards, etc. Keeping track of all your family identity across your household, all your finances, medical. You can see the list here on the screen. A really comprehensive list that we've learned from now tens of thousands of families. These are the things that they want to keep track of, that are important documents. And we hear it from families who haven't built a family operating system yet. Hey, here's what it looks like when we're trying to parse through a relative's estate. It's a nightmare. And it takes on average, what we hear, 18 months at least to do that and figure out where everything lives, what are the passwords, we try and hack those, where are the bills. It's an amazingly time-consuming process that families have to go through if they don't have some semblance of a family operating system. We didn't build it, of course, just for estate transitions or end-of-life healthcare scenarios. We built it for day-to-day. When you're looking for a bit of information, where do you go to find it quickly? How do you get it? How do you get it where it needs to go? Thanks, Kate. So we built a system that spans your whole life and gives you access and utility and agency from your information. So you know exactly where to go to find it, where you can get it, retrieve it, send it on its way to someone who might need it. Could be a family member, could be an estate planning attorney, could be an accountant or wealth advisor, all of the folks that you might have in your ecosystem. And you have the ability to give them just the right amount of access at the right time. Sometimes you don't necessarily want to share everything right away. Nancy talked about this family dynamic of, hey, when is the right time? How do we figure this out at the right time? You might not want your kids to know that they're going to inherit, some wealth yet. And you might not want to have those conversations and create a weird dynamic in your family. So we give the ability to share things at the right time, not just with the right people, but also at the right time. That's an important part of the collaboration that we built. Of course, it's an encrypted, secure vault that helps you store all that information privately and securely. We have household AI now, so you can ask questions about your information and get answers and guidance and take action at the right time. Also with intelligent reminders. And then we have this ability for you to have all your information in your pocket on either Android or iOS application, so that wherever you are, even if you're offline, you still have access to all that important information in the moments that you need it. Of course, we get security questions. How secure is it? How private is it? It's obviously a fundamental part of our brand and our promise to our members is keeping that information private and protected, and making sure that you are the arbiter of that information. That only you decide who has access and when they have access. We do, of course, all the things you'd expect. We talked about encryption, 256-bit AES encryption at both rest and in transit, multi-factor authentication, including biometrics and hardware keys. We do a special extra layer of security called tokenization, which is sort of the level that we wanted to put our own family information in Trustworthy and said this has to be available to everyone. It's more expensive. It takes longer to implement. And I think we're the only one that has it in the industry, but it's that extra layer that we wanted. Essentially what it does is it extrapolates out all the really secure bits of information, replaces them with a hash token that only you have the key to unlock. So essentially like a social security number or bank account numbers, they're all tokenized. Of course, it's not just us saying that it's secure. We go through a lot of rigorous audits and penetration testing and bug bounty programs and white hat hackers and there's a long list of third parties that validate the standards and compliance that we go through to validate that security and privacy for your information. Some of them listed here: SOC 2, SOC 3, GDPR, HIPAA compliance. There's a long list of those as well, and it's ongoing. It's not like something we did years ago. It's every 6 months or every year, depending on the kind of certification compliance that we need. If you want more information in great detail, go to trustworthy.com/security, and happy to answer questions about that. Obviously, really the fundamental part of this is being trustworthy, making sure that you know your information is protected and secure at all times. We have an offer today for you. If you are just learning about Trustworthy and you want to learn more and get started, you can use this 20% off discount to get started with one of our plans. And please email us if you have any questions, support@trustworthy.com. That's the end of my presentation. I'm happy to take questions, I think, across the board for Patrick, for Nancy, for myself, if you have them.
Thank you, everybody. Let's see what questions might have been submitted. All right, do we have any questions? From anyone? I'm not seeing anything in the chat, but you feel free to raise your hand. Yes, Kathy. Kathy, I think you had your hand raised. If you wanted to ask your question, feel free to. Kathy?
Is Kathy able to unmute her mic?
Yeah, I can't unmute you, but you are muted, Kathy, if you are speaking. All right, in the meantime, I think somebody just submitted a question. How to start keeping good records of action taken and what might a good starting organizational structure be? This is from Julie. So it's a good way to start with record keeping or a good, structure. I don't know, Nancy or Patrick.
Sure. So I guess, I'd love a clarification. I mean, if we're talking about financial decisions and you're talking about keeping an accounting to report to the court, that could be different than putting together a portfolio of assets for yourself or for someone else. So I don't know, maybe you could clarify that question a little bit. Because I think between Trustworthy and Advocord, they're two great places to get started. Advocord is a little more, accounting based, in terms of completing the court reports for, looking at where every dime was spent. So they're probably more of a macro, micro type thing.
Yeah. Julie, can you provide any clarification? Starting to take care of mom's finances. I'm her power of attorney and wondering how best to record what I'm doing on her behalf.
Yes, I mean, I would say I'd be happy for you to check out Advocord. In terms of it allows you to track all of her income, all of her expenses. It allows you to keep time records. So if, it will allow you to track how much time you're spending on each task. So that's, like I said, there's a coupon in the Trustworthy Marketplace, and we flashed it up here before. And then once you're in that system, there's a free trial anyway for the first month, and you can chat with us at any time. We do 30-minute chats to help onboard, and we can walk you through all of that.
Great. Yeah, and we'll be sending the presentation and the coupon codes out to everyone too in attendance today. So you'll receive this in your email as well if you want to take advantage of that. The other question we had from Kathy was, can a family nurse practitioner sign a letter of incapacity in California?
I'm not seeing anybody jumping up to answer that question. So who's the audience for this? So the person, why are you establishing incapacity if a power of attorney, for example, says it's not even valid until the person is incapacitated? Well, typically any healthcare professional can I don't want to speak for California since I'm not a California attorney, but in my experience, any healthcare professional with enough familiarity can say, here is not only the diagnostic test that I administered, here's why the person failed it, and therefore they're not able functionally to manage their own money. They're not able to make logical decisions. They put that in writing. In my experience, financial institutions would look at that, and that would satisfy the hurdle you have to get over in the power of attorney itself. To show that it's valid, that the person is incapacitated. But that might not be the audience. I'm trying to think of other audiences where you would be establishing incapacity for a healthcare decision, for a healthcare advance directive, healthcare power of attorney. Typically, that's the treating physician or the treating person who is waiting for the patient to give an informed answer, yes or no to treatment. That person makes that. I mean, I'm not getting anywhere with my patient. So then they make the determination right then and there, and they turn to the person who's authorized to make medical decisions. So it kind of comes down to the audience. Why are we establishing incapacity? But and if it's a family nurse practitioner, you might be developing a care plan for the person, and so that might be part and parcel of the same thing.
Yeah, I would add to that. If you're looking at, guardianship or conservatorship, obviously the statute in California is going to govern, what the level of proof is. But even if it is permitted under the statute, you could find, a particular judge might have a preference as to what level of education and they want the provider to have before, accepting that evidence. So I know Patrick and I just gave you complete lawyer answers on that. It depends.
Great. Thank you both for that. Any other questions? I guess Kathy also wrote, FYI, the ABC Family Trust requires 2 letters from doctors. You don't need to address this if you want to move on. Is there a question around that, Kathy?
So that's pretty much like the power of attorney. So for purposes of taking over as trustee, there is often some standard for if the person receiving care was the trustee, but now there's a successor trustee or maybe multiple successors, who takes over and when. And if the trust itself says you have to establish incapacity to take over, again, who's the audience? Is it, well, I now have to establish with the bank or the whatever other financial institution where trust assets are deposited? That's one question. Is it just for purposes of the beneficiaries of the trust who might be ultimately children? What do you need to do to take over? But it's most likely functionally, if you're trying to make the trust work, your audience is likely to be financial institutions, and you can ask them. But anybody who has examined the person and administered some sort of diagnostic and can spell out, this is why the person can't manage trust assets anymore, that ought to be enough. Now, it said 2, I think you said, Kathy, so it won't be just one nurse practitioner or one doctor. You're going to get 2 different ones to administer this. I guess that was put in place because it's a big deal to take away that responsibility from somebody. And so you have to get that diagnostic from, and a letter or a note of some sort from 2 different sources.
Thank you so much, Patrick. Super helpful. I think that's all the questions we have. Thank you. Thanks everyone for joining. We appreciate your time. As mentioned, we will be sending out the presentation and follow up the cute promo codes as well for Trustworthy and Advocord, and email after. If you have any questions, please don't hesitate to reach out to support@trustworthy.com. And thanks to our presenters, Patrick, Nat, and Nancy. Super informative and helpful conversation that we had today. Thank you all.
Thank you.
Thanks, everyone.
Yeah.
All right. Thanks, y'all. Bye.
Bye.